Woo! Good morning, my friends. Oh my God, I'm so sorry that I am so late. I was walking into my studio and I was ready to get started. And Clubber decided to take off again. So I just came from searching all over the neighborhood for Clubber, and I finally got him back. Yeah, don't wag your tail, shithead. Yeah, you're a shithead. You're a shithead, making all these people wait. So yeah, we're so today we've got the latest motions hearing, probably the last one if this trial starts on April 1st as it's supposed to, as Judge Bev is so dead set on starting. So it should be interesting because at this point the defense just seems fed up. They know that Karen Reed is not getting a fair shake. They know that Karen Reed is being railroaded. They know that everything that they do basically only serves the purpose of being put on the record at this point. No, he didn't go out chasing ass, Connor McManus, because like he's fixed, you know. So he just wanted to run around, check things out. Gerda K, member for 14 months. Thank you so much. And Petty Paralegal, thank you for becoming a member as well. Appreciate it. Did I pre-order Plevin's book? No, I did not. But let's see what's going on the tubes. I don't expect a whole lot of people in here today. Let's see what's going on with Tom before this gets started.
I hope not.
Yeah, they were.
They were. It's in the thing about they talked about the business
I went in
owners.
this morning and requested the letter that they're talking about, referring to that. I asked for that letter.
Oh, well, look at it.
So it's on Saturdays.
Saturdays.
Hey, give Tom and Mike's video a like.
Oh, wait, that's the winter spring.
There's a weekly.
November, December, January, February, March.
Oh, and then weekly.
Yeah. Weekly. On Saturdays. Every week, Saturday at 10 o'clock.
So they're using that as an excuse to get us out of here.
Whoa. Boy, it's a good thing I followed that one down this morning. That's bullshit.
Yeah. I told you it was a farmer's market in there. And if they have to move you that far back, that's crazy.
All right. See these people that support this? Let's take a look at this, okay? Let's take a look at these companies here. Right? Do you want to have an influence and have a say? Let's find out how much of a say you want in the matter here. All these people supporting this? Really? It's a great idea, you know? Who wouldn't support the food bank, right?
Right.
Right? Who doesn't support this? We all do.
I don't even know what the fuck is going on right now.
Really?
Premium bill on it. Wow. Good job, Tommy. I know. I mean, if you have the people there, they'll come out. Here this Karen. Okay, I'll let you go.
Yeah. That's why you were saying. Look out for the camera behind you, Kurt.
Love it.
Well, yeah. It was actually.
Morning.
Ask Alan Jackson how the Lakers are doing.
Hey, how the Lakers doing, Alan?
I haven't kept up with them.
Oh my goodness.
Busy.
Okay, yeah. I don't know.
Well,
Mike, how they doing? Anybody? You guys got a new guy, though, right?
Alan Jackson was like, I've been a little
Not
bit
so good. Not so good.
I know they've got a heck of a new player.
Yeah, the new guy, right?
Yeah. He's supposed to be the best in the league.
Yeah, Luka Dovic. Luka. He can't talk about the case, so we just got to ask him random questions. Ask him what kind of suit he's wearing.
A nice one.
Yeah.
Hey, SD, why love bud? Morning.
Wow, man. There's a lot of people out there, dude. Yeah, Karen's support is just going to grow and grow and grow.
I get your phone call. Gotcha. Stay off your phone. Another way. Let's go. No, I'm keeping it small today.
Yeah, the MSP officers are, yeah, the MSP officers are definitely
Here we go. Here we go.
All right. One up there.
Hi, Jill.
Man,
Are the state police being extra nasty today or what?
what?
Are the state police being nice today?
not
The guy just picked me up and moved me.
Okay.
As nice as he could, we'll say.
All right.
Talk to you.
I just don't want him to get too
Poor
handy.
Tom.
You know what I mean?
Oh, he had both hands on me. I don't know what
Make sure to poor Tom, man.
you define that.
Make sure to give Tom a like, man.
Yeah.
Make sure to do
Yeah,
that.
I've seen he was over there.
You just dropped the link.
Trying to stay away from him. Yeah. Everything you say he's gonna use and chop it up and
All right. Let's Jesus, man. People need to start treating Tommy with a little more respect, man. It's really shitty. This guy just literally like picked him up and moved him. The fuck? What's up, Microdots? Amazing latest video, buddy. We watched it yesterday. Yeah, it's too noisy out there right now. So tonight, I haven't set a time yet, depending on how long this thing is today. But tonight I'll have Nan Gallagher on to do a recap of whatever happens today. So keep your ear to the grindstone. Yeah, like this may not be where all the people are, but this is where all the cool people are. All right. So y'all just know that. Know that. Hell yeah. Yeah, man. This shit's gonna be fucking hectic. But I'm very interested to see what happens here today because the clock is ticking on the clock is ticking on the trial starting, and I am really interested to know what the defense is going to be doing. And I'm even interested exactly like I'm interested in yeah, when is that going to happen exactly, Microdots? When's the motion to dismiss hearings going to take place? And I think they did. They covered. I mean, that was the argument. I think Microdots. That was the argument about Fanning. I think that's when they argued that. But when is there going to be a decision? It's like she just blew it off. Amazing how this works.
Oh, here we go. Yeah.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
I completely agree. Thank you, Drea. Let's fucking go. Yes, I completely agree with you, Richie. They need to have an evidentiary. They need to have evidentiary hearings. They need to they need to have witnesses testify, because this shit is ridiculous. It's the most asinine shit I've ever seen. How dare you? I'm gonna check other shit here to see if there's like a different feed.
Oh, here we go. Yeah.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Dory Yogi, thank you so much. I got chills too watching Microdot's latest vids. I know my husband is watching Overreacting too from okay. All right. Yeah, thank you, Dory. Yeah, I know, listen, I know there's a bunch of rumors flying around about Mazza. There's nothing to it. Like, don't overthink that shit. It's real simple. Mazza needed a break from YouTube. It happens. It happens. Like, it's not that serious. It's not that deep, you know? Like, the bottom line is, you know, he's gonna participate on X, and he needs to take a breather from YouTube for whatever reason. Whatever those reasons are his business. Yeah, everyone needs to step back and take a break once in a while, dude. I've had to do it. Now why he deleted all his content, again, I don't know, but I don't really care. You know, like I care that he's okay. I asked him, said he was fine. That's it. Other than that, whatever the fuck he does is none of anybody's business. Hey, so Plevin's book is available for free on Kindle, y'all. I'm just saying. You can read Plevin's book for free on Kindle. If you got a Kindle, you can read that shit for free, bro. Oh man. Oh, don't tempt me. I feel like I feel like Goat Boy should do that. Have you guys seen Goat Boy do Plevin impressions on Twitter? They're fucking great. I would love to see little increments, just a chapter a day of Goat Boy reading that book. I would love that shit. I'm officially requesting that Goat Boy do this. That just read a chapter a day in Plevin voice. No, I'm not stoned. Fuck, man. In all this excitement, I forgot to fucking eat a gummy. I'm gonna have to go upstairs and grab one as soon as this starts. It's just, dude, I can't even listen. I don't want that microdots. I know, like, in theory, it sounds like a fun idea, but let's really sink our teeth into that idea for a second. I can't even get through his tweets. Like, I find them to be excruciating. I'm gonna read a fucking book this guy wrote. No, dude, I couldn't do it. Like, I would start that shit and then I'd fucking bail. There's no way I'd see that through. There's no fucking way that I would ever see that all the way through and like commit to reading Plevin's entire book out loud. There's just no way. But I would totally like watch Goat Boy do it. Yeah, Goat Boy's impression of Plevin is fucking spot on, dude. Like, that shit is amazing. It's so funny. He's the court TV expert. Bro, I can't even say that shit out loud without laughing, bro. The court TV expert. Plevin, the court TV expert, dude. Holy shit. Oh my God, it's too much. All right, here we go, folks. Seen on court TV.
Good morning, Your Honor. Hank Brennan for the Commonwealth. Good morning, Your Honor. Al Check. Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Judge.
All right, so before we begin, Mr. Jackson, when we left the other day, when we were talking about Michael Easter, I gave you the opportunity to get some authority on expert testimony and voter defense. Were you able to do that?
We were.
Do you have something to file?
Yes, it was filed yesterday. I do have a courtesy copy for the clerk.
Okay, thank you.
And I can, if the court wishes, we
No,
can take that on.
that's,
That's suffice.
I think so. I'll take a look at it.
It's got everything in it that I would say orally anyway, but if the court has any questions, I'm happy to answer any questions.
All right. Thank you. All right, so thank you. So similarly, regarding the third-party culprit argument the other day, Ms. Yannetti, I see you did file something late yesterday, so I got that. I'm just wondering if either the Commonwealth or the defendant want to be heard on that.
The Commonwealth does.
Okay, so I'll hear you, Mr. Brennan.
Your Honor asked for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently, the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose. They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant and national broadcast, there's no evidence of that. There is no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there.
That's bullshit.
2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in a position having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. Then there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply
This guy.
cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were 2 radio personalities, and I have the clip, who spoke and met with Karen Reed. And during the conversations, at least they relate that there was some claims about a drug issue, and according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that there was no animosity between his family and John O'Keefe.
Dude, he called him Nevercracker. What are you talking about?
Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged
Bought him candy.
a very strong claim with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably, it turns out that picture, I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles, subsequently, because he may have done a video that some use would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relevant.
Look at Aiden. Aiden's like, what?
They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general
him owning the house
of strength and distorted into a hopefully perceived sense of violence that it has no root at all. No root. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs. None whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanner Award, has many, many medals of honor from the Boston Police Department, but that is not the issue.
He's a decorated dude.
They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 34 Fairview. So that's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from the
70 feet from his house.
70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make an offer of proof to the court and they're going to make claims to substantiate this theory, they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the Waze data and the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it has not been decided by the court, Dr. Crosby has done molds that show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins according to them was rebuffed because of phone calls at night.
Yeah.
All of these general claims with no fact predicate rely on innuendos.
Dude, they butt dialed each other
speculation,
supposedly at 2 a.m. What are you talking about?
An inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There's not one witness. There's not one statement. That
No,
Brian
just the
Albert
fact that he was trying to
had
fuck his
any
girlfriend.
whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there is no evidence that he was involved.
He had the
in
motive
the
and the
alleged
opportunity.
collision that happened in the front of his yard that night. Finally, the defense turns to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages.
Right.
In the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed went to Mr. Higgins' house. And so there was some interest, it would appear, from the text messages between the two. Mutual.
That's called motive, dickhead.
At best. There's a plethora of text messages where Miss Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. In one, she says, of basically begging him to come over. Do you like me? Come over to my house. There are text messages
do you like
talking
me?
about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe.
Try about half of every other murder case. Every other high-profile murder case. Try like half of them.
Because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins' text messages are virtually all kind towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion that there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit.
Well, the fact that he ended up dead kind of contradicts that, dude.
Saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that
Plevin.
Not going to come in when they arrived at the house. Is it reasonable? Is it rational? Is it lucid to think that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them, or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways? The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It would be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend. It will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from.
That's called presenting reasonable doubt, you dumb shit. It's their job.
That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. They, as their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So they are parsing words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence.
Wow.
They have no evidence of a weapon. What we know is John O'Keefe never went in the home.
Where's Bill and Janet?
So to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been reported have actual people who could be a third-party culprit. who actually have relationships to the scene or the crime or the deceased.
You mean like
In
Brian
this
Albert?
case, an attempt to call Mr. Higgins
Colin
a liar
Albert?
or create fictions about what they think he could have been doing or guessing what they want him to do is not evidence. 9 people testified John never came into the house. 9 people. There is no overwhelming evidence or any evidence he went into the house. There is no evidence of motive on any of these 3 people they identified. They've had, before the last trial, the entire trial, and was aptly pointed out, no request for a third-party culprit instruction. And then they had since then to make an actual proffer that people actually have the motive, opportunity, and intent to do this. That is actual evidence that there's this alternative theory, and they failed to do it. To have the defense
Doesn't
go to
have to be.
trial, distract the jury, attack the reputation and character of the witnesses, and then not even ask for an instruction.
Thank you, Scott.
At the end. It evidenced the fact that there is no basis for a third-party culprit. Now, separately, third-party culprit is part of Bowden. Even if the defense at the end does not warrant an instruction, I recognize that challenging a police investigation is virtually an entitlement of a defense. How they do it and the extent they can do it is a different story. Simply because they have an attack on the police investigation does not let them use third parties as part of that. And so the standard, Silva Santiago, is very clear, it's cited by almost every case, is that there has to be something the police didn't do at the time that they knew about and should have done. So at the time the police did their investigation as being criticized, they would have had to have known about a potential third-party culprit or third-party culprit evidence and didn't pursue it. And that's where the defense argument utterly fails here. Because at the time the police were doing this investigation, what they knew is that John O'Keefe was on the front lawn of 34 Fairview near the street. They knew that he was dying or is dead. And a number of witnesses knew that Miss Reed was saying, I hit him, I hit him, I hit him. A number of witnesses.
All not credible.
What the police knew is that Miss Reed's taillight was cracked. And shortly after, what they learned and knew after they got her car is that part of her taillight was missing. So at that time, when they were doing their investigation, there was no claim of dog bites. That came months and months later. They went to 34 Fairview and they spoke to the owner, according to the witness testimony. And everything seemed appropriate. Concerned, confused, no blood, no scratches, no cover-up, no turned over furniture. There was nothing that would have alerted the police officers that there was any road to follow other than the road they followed. Now they can be criticized for plastic cups or leaf blowers, but that's different. That's different.
No,
In order
no.
to have third-party culprit,
It's still
the
shitty police
had
work.
to have known that there was information that targeted or pointed out a different person, and they didn't pursue it. So in the cases cited by both the Commonwealth and the defense, there are a number of cases that talk about information that was known to police at the time they were investigating and they failed to pursue it. That is not this case. That is not this case. There is nothing in any of these proffers that show actual evidence that the police knew of these later third-party culprit claims by the defense, or they knew at the time they were doing this investigation that there was any other lead. And likely the reason is because there wasn't. The evidence for a reasonable police officer pointed.
They didn't even question the witnesses.
Statements.
What are you talking about?
Towards the light. And that was followed up, which led to DNA in hair and all the other evidence that followed, the data. And so as a concession to the defense, they don't simply get to bring in third-party culprit through Bowden because they failed in the instant case to show a third-party culprit. That's not part of their entitlement. And mindful that if they do raise Bowden, whether they get instruction or not, it is broad. And that means the police, including any police they would call in this case, or we would call, is entitled then to share their state of mind, why they did and did not do something. That can open doors to inadmissible evidence, privileged materials. The state of mind of the officer is relevant if they make it relevant. So we should not engage in a
Thank you,
process
Liz Reed.
where
Appreciate
we
it.
allow witnesses to be asked questions with no ability of the defense to follow up those questions with actual proof. We should not engage in a process where witnesses, their character is attacked when it has no relationship whatsoever to this crime. And witnesses shouldn't be put through the ordeal of defending themselves based on generalizations about supposedly being violent or having a temper. There needs to be that nexus, and it fails. It is beyond feeble. And so I ask Your Honor not to allow third-party culprit in the instant.
What's
and
feeble
should
is
not
Colin's
allow it
attempt to
follow.
fight and be a tough guy. That's feeble.
Yes.
This could be awesome.
Your Honor, the Commonwealth's motion raises three interconnected issues, not just two. I believe that two of those were conflated by the Commonwealth. I'd like to separate them out. The first issue is the introduction or admissibility of evidence relevant to show that somebody else harmed John O'Keefe. The second issue, which I think was conflated with the first, is whether after the introduction of such evidence, the defense is allowed to argue that a specific person or persons caused John O'Keefe's death. And then the third issue is whether the police properly investigated this matter in light of the information that they had or information they could have obtained or failed to follow up on to show that somebody else caused John O'Keefe's death. Regarding the first issue, which Mr. Brennan spent a lot of his argument on, there is ample evidence tending to show that somebody else caused John O'Keefe's death.
Ample.
In our opposition, we have cataloged the evidence against each of the potential third-party culprits that we named the last time we were in court. Each one of them had a motive and an opportunity to harm John O'Keefe.
That's right.
The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those
Get him!
are on our witness list.
Sucker
He's been
punch.
investigated by the Boston Police Internal Affairs for having done so. There are many police officers listening to this argument right now who are nodding their heads. We've heard from many of them. It's undisputed that
I love
Brian
that.
Albert was present at the scene of the crime. It was his house. He claims to have been sleeping merely several feet away from where John O'Keefe's lifeless body was later found. There is evidence that John O'Keefe entered Brian Albert's house. The Commonwealth may not agree with that interpretation of the evidence, but it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period.
Right.
That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night
attached at the
that
butt.
after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had
Lovey-dovey.
expressed his interest, but it went nowhere. And it went
Nowhere.
nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well.
Liquored
They're
up.
both very large men. The court saw them on the video.
Very large men.
Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house.
That's it.
After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls.
5 minutes before the 2:27 a.m. search.
Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm, consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past. It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result.
Nope. He's a cop too. He's a Boston cop too.
I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higgins were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael Proctor said, nope, the homeowner is a Boston cop too. The message was clear. If you're a suspect, you get fully investigated unless you're on the right side of the blue wall. If you're a police officer, you get a pass. Now, in addition to the 2:22 a.m. phone calls with Higgins, there's other consciousness of guilt evidence implicating Brian Albert. And I would note, this is not something that Mr. Brennan addressed in his argument. He didn't talk about the consciousness of guilt evidence. Despite a massive police presence on his front yard, just feet from his bedroom, Brian Albert never came out to speak with investigators.
Nope.
And it's worth noting, it's worth stressing that Brian Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack.
Another state of life.
Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case. It's evidence that he had the motive, intent, and opportunity to hurt John O'Keefe. Brian Higgins is another potential third-party culprit. Like Brian Albert, Brian Higgins was present at the scene of the crime. He was
had the
there
most
at
motive.
the relevant time in the house, again, unaccounted for. At the same time, John O'Keefe would have been there. Brian Albert had cause to back up his friend, but it was Higgins himself who was the one who had been flirting with Ms. Reed in the weeks leading up to January 29th. He testified that she kissed him goodbye after they had watched an NFL playoff game at a get-together not long before January 29th. He testified that she had visited him at his apartment after that, but he acknowledged that their text exchange and all contact between them ended, and Ms. Reed was the one to end the contact. She stopped responding to him. She no longer gave him any attention. So we come to January 28th. Brian Higgins sees Ms. Reed in person, but she's not alone. She's instead with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Alberts' house that night, In fact,
I can't get over that,
he
Connor McManus.
appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness of guilt as well. After a long day of driving and drinking, Higgins leaves Brian Albert's residence, does not go home. Instead, he goes to the Canton Police in the early morning hours. He initially claims he went there to do administrative work. He changed that testimony at trial to him going there to move a vehicle. But he's always maintained, including in the first trial, that he never called anyone. We've learned since that trial that Higgins is at the station on video making a phone call. So I suppose the question is, why did he lie about that? The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous.
It's fucking
And there's more
ridiculous.
consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself.
Yep.
And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object, the size of about a thumbnail, into a large...
Are we talking about a SIM card or his dick?
It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt of Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And
Dude,
finally,
you win handle of the day, Glaze Anatomy.
He's been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life.
Yep.
Yet there are videos of him clearly desperate to beat up others.
I got one queued up right
Colin
now.
Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles looked consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo. We don't buy it. We don't think a jury will buy it. When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview. His uncle
I noticed that too, Alan.
on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even know who he was. But we found out when we sent a letter to Mr. Lowry, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter notifying the prosecution that we were on to Colin Albert that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address. There appeared to be a conscious effort of these investigators to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allowed in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Como versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, a person was murdered inside a home.
When did Bull Hurley become a bailiff?
Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed.
You ain't shit.
That was enough. Here we have hard evidence, irrefutable evidence, that the three potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial after the first,
If you know, you know.
The first trial conviction was reversed. The defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, the defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error not to permit a full third-party culprit defense, including prior bad acts of the third-party culprit. And I will ask the court to consider Como versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried for retrial of that case, so I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed a crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. It's sort of like Conkey, where it's just assumed, yes, of course you can present a third-party culprit defense. But in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer was yes. And in Finney, of course you can present a third-party culprit defense. But can you also introduce hearsay to support that defense? It was a given. In fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy.
Of course.
Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition.
There you go.
Along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. I would note, Judge, there's I believe a certain amount of gaslighting going on here, in that on one side of his mouth he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to
yes,
just limit everything. He's
get him.
I believe acting more like a defense attorney than a prosecutor.
Woo!
Regardless, in terms of these cases, Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim. and or relationships to the scene of the crime. Finney did not. In Finney, my client was the next door neighbor. My client signed a confession to the murder. The third party culprit lived several houses away within the same city, but not close, not next door. There was no relationship other than he made statements about how the victim probably deserved what she got and she wasn't the goody two shoes, but there was no, that she was made out to be, but there was no witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime. The SJC ruled even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue I suggest that the court does not need to decide now in advance of trial. Closing arguments come at the very end of trial. At the charge conference, this court would be in a position and would be entitled to evaluate the evidence as it came in and to make a decision at that time prior to closing arguments as to what we can argue and what we can't. And while we believe the court has enough evidence now as a result of the first trial and as a result of our proffer and our submissions and oral argument today to rule that a third-party culprit defense is permissible, but this court at a minimum should not deny argument on that issue before evaluating the evidence as it comes in. And that brings us to the final third issue, a Bowden defense. Obviously, attacking the inadequacies of a police investigation is bedrock constitutional law. It's a bedrock constitutional right. In this regard, in one sense, the discussion about the third-party culprit evidence is somewhat academic as opposed to a practical one, because all of the evidence that points to Brian Albert, Brian Higgins, and or Colin Albert, all of it comes in to show the lack of investigation, the lack of curiosity that the police had, and the lack of investigation that they did to rule any of them out. And it comes in to show the bias of the investigators of this case. Bias is also a constitutional right. They were perfectly willing to jump to conclusions about Ms. Reed, someone outside their law enforcement circle on the wrong side of the blue wall, but very much unwilling to be curious about whether someone within their circle had the motive, opportunity, and means to hurt John O'Keefe. Former Trooper Proctor specifically told his friends he had no interest in investigating someone connecting with law enforcement. And in their internal affairs findings, his superiors noted that his apparent bias was one of the reasons he was fired. You can't have a stronger Bowden defense than that.
There you go.
So I would argue, Judge, that the Commonwealth's motion really comes down to what the defense will be able to argue in this case. Our position is we should be able to point the finger of guilt at those who might have done this, but at a minimum, given that the evidence will be coming into trial anyway on the Bowden issue, the court should reserve judgment on what we would be allowed to argue from now, weeks from now, when closing arguments are upon us. This evidence, in conclusion, in our view, must come in. This is a due process constitutional right of my client.
There you
And
go.
it has to be admitted for two reasons. Number one, it's a time-honored method of defending against a criminal charge by pointing out that somebody else could have done this. And number two, it's a time-honored method of defending against the criminal charge by pointing out that police investigators failed to do their jobs correctly. We have a stronger third-party culprit evidence situation here than existed in either Conkey or Finney. And we assert it would be reversible error for this court to exclude this evidence. Unless the court has further questions, I would rest on my memorandum.
I can't believe Bev didn't interrupt him at all. That's amazing. Let's see what kind of bullshit this dude spews out now.
I'm going to choose to focus on case law and the facts that aren't presented by the defense. We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical because there is no basis to accuse somebody of
His Apple
murdering
Health
another
data,
person
dude.
if they don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple derogatory words. In Finney, as counsel knows, there was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular. And because of this irregularity and the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so, no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't.
It
They
does.
don't have a problem. So
It's
there is
called
no
his Apple Health
opportunity
data. It does.
to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision.
No, none of the evidence does.
The defense's effort to tell a story, take a couple of facts. Someone's a boxer, they drank alcohol, and convert it into a story is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes.
They are,
but there
though.
limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth
No, you're
should
whining.
not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced because it is inevitably, it diverts jurors' attention away from the defendant on trial.
That's called
not
creating
third
reasonable
party.
doubt. It's the defense's
Essentially,
job.
the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want. And I don't begrudge that at all. There's different interpretations to it. I understand that.
Come on,
This
dude.
was
Stop it.
Heavily considered in the federal investigation. And after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments. And
Oh, you
so,
mean
although we don't know
the
parameters
thorough
of the
investigation
we
that
can only
proved
guess
that
that's the
Karen
number.
Reed didn't
We
hit
know
John O'Keefe with her SUV?
review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Albert came down the stairs, the testimony is the police
It
officer
creates
was calling
reasonable
inside the
doubt.
home. There's no evidence Mr. O'Keefe, a first responder, was still outside that aid could have been rendered. That is just, it's not only speculative, it's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth versus Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later, the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth versus Moore. The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth versus Buckman, 461 Mass, 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole to look like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward. Facts suggesting that one side believes a person's telling the truth or not is not facts of third-party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury. And I don't think the basis is anywhere close. It's feeble.
It's reasonable doubt, dummy.
First of all, Your Honor.
Oh, he means business.
Speaking about the federal investigation, when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. Should not be a part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. Court ruled in that case there weren't. In Finney, there were. And with regard to the other case, well, I'm sorry, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone, and we'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the trial driver, Mr. Lothran, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. And unless the court has any questions, I would rest on that.
I mean, what else do you need?
Let's go on to paper 620.
Oh, she lives. I was gonna say, has anybody checked to see if Bev was breathing?
Unsolved Productions.
Yeah.
This guy's such an asshole.
Your Honor, the Commonwealth filed a Rule 17 motion for records from Unsolved Productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We served the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week.
You're fishing, dude.
There is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements to the defendant. They're admissible substantively. They're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use the time we can to sift through. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they're forthcoming with the court order.
There's no one here from Unsolved Productions opposed to this.
There is not.
Trace the signal.
Your Honor, we're unaware of the communications back and forth between the Commonwealth and the production company. So we've not been privy to that. This is the first we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing officially has been filed one way or the other. So we're not in a position to argue on their behalf, for sure.
All right. So, we have 2 things left to discuss. I want to talk about jury impoundment. We also have a Commonwealth motion regarding Mr. Yanetti's appointment. Mr. Yanetti, it's 10 past 12. Which one do you want to go forward on first? Do you want to talk about the impoundment, or do you want this motion?
I'm not handling either of those.
I understand, but do you have a preference with some before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and attorney stored within the defendant's document.
God, I'm so sick of this fucking
Your
asshole.
Honor, so I'm clear, the Commonwealth is not seeking all communications between Ms. Reed and Mr. Yanetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions.
You imagine how angry Yannetti is right now?
We believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege.
Wow, dude. Piece of shit.
Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yannetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yannetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023. And the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, did I hit him? I hit him." And the answer by Ms. Reed was, "I said, did I hit him? Question mark. And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's culpability there. And I thought, all right, maybe this is maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like?" Similarly.
What? Look at Aiden's face.
Documentary series.
The fuck are you talking about?
Ms. Reed is video and audio taped, and it was presented on television that she said, "And then when I hired David Yannetti, I asked him those questions the night of January 29th, like, David, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe in her vehicle.
Jesus, dude, you are reaching, bro.
Conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential.
Right.
Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. This was intentional. It wasn't secretive. It wasn't overheard. It was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any text or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
You're a fucking weasel, dude.
I am, Your Honor. Boo! You suck!
Unless he's going to knock this shit out of the park.
May it please the court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yannetti. 2 of the 3 instances of the communication they cite to are over 9 months old, and that's in 5 months old respectively. So you have 9 months ago the Gretchen Voss statements, and 5 months ago the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion.
Woo!
The courts
I love
are
it.
clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the 3rd communication, the HBO Max one, it regards the same event that is discussed in the first 2. There is no addition of an event in the 3rd one. So that 3rd discussion, the docuseries, regards the same events that have been extant in the first 2 that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers.
Get 'em!
And it should unsettle every criminal defense attorney in this Commonwealth. And I
Like you,
would dare
Bev.
to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law. And this Commonwealth has
I didn't know that.
identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions, as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case, and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites the Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you.
What? What's going
I
on?
understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me.
I love it. Nice. Way to go, Bev. Way to go, Bev. I love it. Bev did something good. Amazing. Let's give her a round of applause. Let's do that.
We need to talk about the panel. The parties need 5 minutes.
Bev might be coming around. I don't want to speak too soon, but she might be coming around. She didn't cut Yannetti off once. Yeah, like Brennan, you're fucking reaching. Even Bev was like, dude, I'm just gonna stop you, dude. Like, I don't even need to hear anymore. This is not okay. That was, I am pleasantly surprised at Bev right now. Pleasantly surprised. Like, if that doesn't confirm right there, Bev cutting off Alessi's argument, being like, you've already made a good enough point here. There's no fucking way I'm approving this motion. I am absolutely going to deny this shit. She's a defense attorney. Before a judge, she was a defense attorney. And that really drove it home. This should concern every citizen. This should concern every defense attorney. That this dude could just pull this out of his ass less than 2 weeks before the trial starts, and he wants to invade someone's attorney-client privilege, whether it was waived or not. And I love that, because Bev pointed that out. Remember when I first talked about this, I said, regardless, I understand the waive. I understand the legal ramifications that she technically waived it. But on a moral, ethical level, this is just plain wrong. That should still be protected. That conversation between her and David Yannetti should still be protected. That is the nature of which Brennan is trying to use, where this is coming from, is dirty and ugly. Mike B from the 413, what's up, buddy? Could she be worried that the first circuit case upcoming broader look at the entire case is possible? Maybe. I don't know. Listen, I'm not going to speculate as to what happened there with Bev. I'm just going to take the win. I'm just going to be happy with it. Captain Skidmarks, thank you. Where did she say we couldn't hear her? I don't know. I don't know what that means. But yeah, I'm just simply going to accept the win right now, because not only did Bev deny the motion, she also cut off Alessi's argument. The one time that she would cut off the defense that I was actually happy about, because it seemed like Dude, Alessi already drove it home. He already did. She was already troubled by this. She was already bothered by this. So the fact that she even cut off Alessi's argument and then said, hey, I understand the law. I get it. I get that she waived her right, but I'm not going to fucking approve this motion, dude. Like, I'm not doing it. No way. Play it again. I could hear her fine. You guys need headphones.
In obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here.
I could hear her fine.
And their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan. I don't even think it's appropriate for me to have, so your motion's denied.
I don't think it's appropriate, so your motion is denied.
Thank you, Your Honor.
That's it. I mean,
We need to talk about impanelment.
I find that to be absolutely amazing. That was the first fully, what I felt to be fully ethical thing that I've seen Bev do since I started following this. That was the first expression of integrity that I saw her really express right there. Well, yeah, see, I can't lower myself, JJL, but I can lower you. See how easy that was? I could absolutely lower you. Yeah, the sound in the courtroom's not that great. It is what it is. Not my problem. So yeah, that was such a breath of fresh air right there. But I don't want to get too comfortable, you know? I don't want to get too excited about it, but it was such a breath of fresh air for Bev to make that decision because, you know, that's just too far. It's just too far. You want conversations between her and her attorney, and you're pulling this out like you're showing the world that you are trying to railroad this woman. You're showing the world that you're trying to rob her of her rights to a fair defense. It's an attack on David Yannetti and on his privacy and on his integrity. And it's not okay. And I think I mean, dare I speculate that I feel like I see a shift in Bev, and I can mark the point when it happened. The shift was when David Yannetti just kind of said, fuck it. Like, she seemed like, no, Mr. Yannetti, I'll hear you, blah, 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 because he was, at that point, he was like, no, you know what, Your Honor, if I'm not going to be heard, then why do I bother? What, you know, what? I don't have anything to say. And she was like, no, Mr. Yannetti, I'll hear you, blah, blah, blah. And then she shifted. And then Yannetti made that amazing argument. And today he made an amazing argument. Today's argument was absolutely beautiful. And I love that he called out Brennan. Like, dude, this guy is on one side of his mouth saying that it's important that my client get a fair trial, yet he's doing everything he can to prevent her from having a fair trial. Like, this is so crazy that we're at this point. Because dare I say, too little, too late, Bev. You know, like, because I mean, as much, and I know I was talking about taking the win and everything, but let's not overlook the fact that this case shouldn't even be going to trial. This shouldn't be happening at all. She should absolutely dismiss this case. At the very least, have an evidentiary hearing. At the very least. And then, of course, you know, there's sweet old Colin Albert. I mean, not violent, right? Colonoscopy. Exactly. What a sweet kid. Ridiculous, dude. Just absolutely fucking ridiculous. This case should be fucking dismissed. So crazy. Aiden wants to apologize for the incidental crotch shots. Paul O'Keefe is rubbing off on him, he guesses. No glazed donuts, though. Look at this. Microdots is already fucking clipping shit, dude. Let's watch some highlights. Let's watch some highlights.
So Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth.
Of course you are.
You're not going along with their theory of the case. Mr. Brennan's aggrieved that we would deign to present this defense. And I would note, Judge, you know, there's I believe a certain amount of gaslighting going on here in that on one side of his mouth, he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard. Regardless, talks about, well, you can't do
Microdots fucking clipped that shit. I love that Microdots clipped that shit. It's fucking fantastic. I gotta repost that too. Like, yeah, and the trolls are just so desperate. Like, bro, RG Larry Legend, dude. Stop it, dude. Look at this. Oh my god, dude. Hold on. What does it say? Hold on. The Karen Reed murder trials. The second trial hasn't started, but I'm writing about it, and I put it on the title of my shitty book, Storm of Suspicious Shit. It's so childish. Trials of the decade as examined by a moron, Clevin Linehan. Holy fuck, dude. Court's not back yet. I've got it right here. Well, maybe actually. Hold on, I gotta fast forward it. It might be back. I was behind. Yep, court is back.
All right, so I don't have a problem with that, but it makes sense that we put it after 8. Those series of questions.
No objection to that.
All right, any objection to question number 13 and putting it at 9, Mr. Vernon?
I don't have any objection to moving it after 9. I think it's a bit one-sided. It leans towards one-sided, but I don't have a strong objection to it.
We can balance it if you want to suggest some language.
If there's an invitation to balance, I'll need a moment.
All right, so you can suggest something at some point. All right, so now moving on to the second page. The Commonwealth's number 17 seems appropriate to me, but if you were working for the same document, it's not in the defense when it was removed, I guess. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair and impartial in this case? I don't have a problem with that question. Does the defense?
We didn't have a real objection to it. It just wasn't a particularly useful question. We thought of the last trial. Everyone said no. So in furtherance of trying to have additional space for more helpful questions, we just decided to exclude it.
All right, I think we'll keep it. There's one I do want to get rid of that caused problems last time, but we'll talk about that in a minute. All right, so thank you. So question number 23 on the defense. Does the Commonwealth object to that question? I think it needs to be tweaked at the least to this little.
We do.
All right, so what's the objection?
I think the question, the way it's written, invites a juror to potentially not follow the judge's instruction. And so I understand the attempt, the idea of it, the germ of it, but the way it's written, it invites, I think, a jury to, or a juror to usurp what their role is.
And what do you say to Ms. Little?
I think if we just tweak the language a bit, I mean, we're happy to hear some proposals from the DA as to sort of the particular issue they have with this question. But I do think the question about the judge's instruction regarding, you know, you're entitled to your own independent individual verdicts.
So they're always told that their verdict must be their own. So there's language in there's probably language in my preliminary instructions, there's language in the charge, certainly. So if it mirrors that language, I don't have a problem with it. Otherwise, I might. So
we can mirror the
talk to each other about
the charge.
All right. So
we would agree to that as well.
Okay. Thank you. Number 25 in defense. If you had to vote today on whether Ms. Reed is guilty or not guilty of the crimes charged, what would your vote be? I tell them throughout the trial, they're not to speculate, they're not to make up their minds until all the evidence is in. I'm not going to even suggest that this is appropriate. So I'm not going to include that. there are enough questions on reasonable doubt, presumption of innocence, and defendant not testifying. So that's out. So the question also, is there any reason why you do or do not want to serve on this jury? I don't think we should invite them to decide whether they want to sit in this jury or not. I think we did give this last time. I don't know what the responses were. Does anybody have any information on that for me?
I think most of them were no. I think 27 kind of hits the same sort of, if
Right,
you have
if that-
general concerns about the case, so I don't have a strong objection.
If that's what we're getting at, we've got it in 27. So I'm inclined not to put it on there. Again, I can hear from you beforehand, probably in writing. I don't want to bring you back.
May I alert the court's attention, there's two on the first page that were slightly worded differently in the Commonwealth's proposed questionnaire and the defendant's
Oh, okay, which
proposed
numbers?
questionnaire. If the court looks at.
I didn't do anything. That's better. What do you mean?
Defendant's questionnaire, we had kind of combined the Commonwealth's proposed questions 4 and 5.
Yeah.
So that it's one question.
So that's what, and I just got rid of Commonwealth's 5.
Perfect.
So this one's better. So we will use that.
Okay, and then number 7 that was proposed by the defense, that is the similar question as number 8 in the Commonwealth's proposed questionnaire.
Yes.
It's just different language.
I thought it was the same.
So we changed it to say, would you tend to believe or disbelieve law enforcement officers, firefighters, or first responders more than a civilian witness simply because of their occupation, as opposed to automatically believe?
So we typically ask the automatically, what's the Commonwealth's position on this?
I have a strong preference. I'll defer to the court.
All right, so I will think about that.
Thank you, Your Honor.
All right, so the question that I don't like, and you may remember, causes a lot of jurors to say, I have no idea what you're talking about. 21 on the Commonwealth's, 20 on the defense. So you may find a defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the difference between circumstantial evidence, speculation, guesswork, and surmise?
I'm sorry, can you repeat that?
It's your number 20. I'm not going to read it again. It caused a lot of trouble before. I think in every single one I had to repeat myself with the instruction that I gave in anticipation of this. I gave them a pre-charge on circumstantial evidence and not being able.
Yes, just the way that it's phrased in the Commonwealth's questionnaire, it makes it seem that the Commonwealth doesn't have to meet their burden of proof.
I think it should be omitted completely.
I have no issue with that. It's just the way that it's
Does the
phrased in the
Commonwealth?
Commonwealth's questionnaire.
It's too confusing in my mind.
Okay, it took up, if you remember, it took up an inordinate amount of time, virtually every single juror.
We have no problem with that.
All right, so that will be omitted. All right, so that's that. Ms. McLaughlin, I think you said, and I think I.
Feels like we're getting closer and closer because now they're discussing questionnaire, jury questionnaire.
95 pages of it the other day, and I didn't see it. Where does this third page come from? The publicity.
The questions come from Chisholm that were asked in the jury questionnaire. The other, some of the other cases, questions were part of the jury questionnaire of the prior trial that just moved over to this page. So this page dealt with a questionnaire exclusively of the trial publicity.
Okay. All right. I think that we all know many, if not most, and perhaps all potential jurors have heard about this case. Giving them the opportunity to write the details that they recall down may take an awful lot of time and space that we don't have on this form, and frankly, I don't think we have. So, what are your positions on, what's your position on 3?
Here, if I may, I can just hand up the excerpt from the Chisholm case that outlines the.
All right. I'm not sure 2 lines are enough space for it, frankly.
What's up, Scott Messerschmidt? Good to see you, buddy.
All right, I guess we'll see what we can do. I didn't realize it came directly, same language. Okay, looks like we're giving this third page of the questionnaire. Yes, Mr.
Your Honor, I want to bring to the court's attention something about the court and counsel just discussed question number 7. Could I ask the court to direct its attention to question?
Which page?
Sorry,
Current page or previous page?
The defendant's questionnaire on the first page. That was the question. I think the court's going to consider whether to use the word automatic or tend to.
Yeah.
I believe that should be broken into 2 questions. It doesn't tell us anything. For instance, the way it's written in the disjunctive, would you tend to believe or disbelieve law enforcement officers, firefighters, first responders more than civilian witnesses just simply because of their occupation? If someone says yes, we don't know if that's believe or tend to disbelieve. So I think if we just break it into 2 questions and now we've got the space to do it, that would be more instructive.
Why does it matter if it's an automatic belief?
I'm not worried about the automatic part. It's the believe or disbelieve. That's the part that doesn't help us.
Right, so if it's automatic, simply because of a person's occupation, this juror would automatically either believe or automatically disbelieve. How does it make that person a fair juror? Why do you need it?
Because that tells us, it would instruct me at least, it would enlighten me on how to further question that juror. If someone says, well, I'd automatically disbelieve police officers, or I'd automatically believe police officers. Those are 2 very different mindsets.
Yeah, it's pretty important.
I'll consider it. I think we keep it as 1, and then if they say yes, we inquire.
Okay.
Maybe. Let me see.
Okay. Thank you.
All right, so it looks like we have the 3rd page as well. I think,
Okay, I want to be very clear about something. Every single person in my chat whining about my sound can kiss my glaze. That'll be all.
if we take that question that Mr. Jackson just talked about, I can ask each individual juror, if I use the tend language, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because he or she is a police officer? And then conversely, would you tend to disbelieve a police officer simply because he or she is a police officer? I typically do that at sidebar in every case, asked exactly like that. So it makes more sense to me that we do it that way rather than a questionnaire. But if you want it on the questionnaire, we'll stay as is. So what's your thought, Ms. Lynn?
That would be the defendant's preference.
Do you care, Mr. Brennan?
We prefer a questionnaire.
All right, so I'll think about it, I'll do it one way or the other, and you'll know next week. So one of the things that I was considering doing, so we have a lot of jurors coming in next week. On Tuesday, 218 jurors have been summoned, is my understanding.
218 jurors have been summoned.
Portion of that, we will get some fraction of that maybe, just on how it goes with whether people are here and available to testify on that date. I mean, to serve as jurors. So say we get like 150 or 175 jurors. I have my remarks to sort of just direct them to what their job is, as you remember, and then I leave when I give them the questionnaires. My guess is for the jurors to fill out this questionnaire, have the questionnaires collected and copied, might take an hour and a half or 2 hours if we have a really large number of people. What I intend to do, at least on Tuesday, is have all the jurors fill out the questionnaire, however long it takes. And depending on how many jurors we have and what time it is, maybe take 50 of the last jurors.
Wait a second.
Send them home.
Is Bev getting some?
Next day at 11 o'clock. If we've got fantastic court security.
She's all made up and everything.
We've got a courtroom to keep people in. There are a lot of things we have to juggle to get this done, and I don't want to waste jurors' time. So I would send them home, have them come back the next day at like 11, so that then the next day's jurors at 11 o'clock can spend that hour and a half, 2-hour process, filling out the forms, having them copied, given to counsel, and we can continue on with those jurors. So it's something we can decide on Tuesday when we see how many people are here, how many jurors we get, how many jurors the district court needs. But is that a process that you would be willing to do? Mr. Brennan?
Of course, no objection.
All right, so we'll try and figure out something that way to get things moving that way. All right, the list of witnesses, you both have a list of witnesses. I told you you needed to combine them so that I can read that to the jury and a statement of the case to the jury. Do you have that yet?
We have not combined them.
All right, so I need you to look at that, and.
Y'all are fucked up.
Read to the jurors. It's all part of the final trial conference, so I should have had it last week. So I need that by Thursday. Is there anything else we need to discuss today?
There's still a few outstanding issues. One is parking. And
Where do you
so,
stand with discovery on that?
I received some TUI letters last night. It is not the information I was seeking from my motion that was allowed by the court. And so I have grave concerns about waiting for the day before.
Oh, shut the fuck up.
Discovery that I think I'm entitled to.
What do you say, Mr. Jackson? James Jackson.
Your Honor, I do not know what Mr. Brennan is referring to.
I don't know what the fuck he's talking about.
What he's looking for and grave concerns. The hyperbole is unnecessary.
So there's a motion, so that should be able to, there was a motion for the discovery allowed a while back.
It
So that
was.
should narrow.
Right.
Right?
Right.
That should narrow things.
It does, and we have not, I attempted to confer this morning with Mr. Brennan, and my recommendation to the court would be for us to confer further, because I just don't understand what he thinks is out there, but we haven't conferred fully either.
Okay.
Right.
All
Like,
right,
what
so
does he want?
we can address this next week. I think we probably have plenty of time to sort of tie up loose ends during the impoundment process, because I think it's going to take a very long time.
Exactly, Brad Blankenship.
Understood. And I expect we'll file a response to a proposed expert. We received their report last night. And I didn't receive it until later, which I want to have a chance to respond to.
And Your Honor, if I could, please, one more item when it's appropriate for Your Honor.
That's okay, go ahead.
Thank you. We did receive the, Your Honor may recall the argument over Dr. Welcher in Your Honor's direction request, and then the assent of the Commonwealth that they would redo what they had provided, that 140 slide presentation. We did receive that, but we received a lot of other material in addition to that, huge megabytes. I haven't even been able to open it up. It takes so long to open it up. I respectfully request that we, Your Honor, grant us please 2 more days than what we had to take a look at that, because it's just taken an extraordinary amount of time.
Makes sense, Mr. Brennan?
I can be clear, there's no new information. What Mr. Welch did is that all the information he basically his opinions on.
Ass Welcher.
Provided to the defense, but he wanted to make it as seamless as possible, so to effectively hold their hand through it. He put each site under each slide so they can find it in the file folders exactly where it is. So it's instructive and helpful, but it's not new.
Your Honor, if I may, I don't disagree with Mr. Brennan's characterization. However, it is still 140 slides or so. I was expecting a rather substantial narrowing. So what we have to do is we have to go, and unfortunately, I think Your Honor is going to hear similar points that we made, but it's going to take more time, because I had the expectation, maybe unreasonably so, that it would be a narrowed slide presentation. So I'd appreciate the 2 extra days.
All right, so when does that put us at? What was the time frame originally?
I'm sorry, Your Honor, I don't have the specific date handy right now.
The time frame as far as the response.
Yes.
Well, we were supposed to exchange discovery yesterday. And so I had that presentation sent over last night. They sent over the 2 letters, and I received the third dog experts report.
If I could, Your Honor, maybe Attorney Brennan misunderstood the question. He is correct that he provided us with the presentation last night, but the question, I believe, Your Honor, was when was our time? Because Your Honor had given us time to respond, and I apologize, I don't have that date, but what I'm just asking for is 2 more days beyond it, but
I don't think I gave it to you.
yeah.
So you have 2 days to respond to that.
I have 2 days from today.
Yes.
Okay.
All right. So there are a few matters outstanding. I will have the decision on the motion to dismiss, should by the end of the day, buffer zone, probably by the end of the day. And I'll get everything else done as quickly as possible. All right. Anything else?
The only other thing is the logistical issue as it pertains to both the voir dire process as well as during the trial. I wanted to ask the court if there was a mechanism by which Ms. Reed could have at counsel table some sort of an earpiece or headphones or something that's slaved to a microphone up at the bench at sidebar so that she can listen in on both. It's very
interesting.
I want to avoid that if possible. It's clunky. Especially during the voir dire process. I think it would be uncomfortable, and quite frankly, I think it would be a little inappropriate to have jurors with Ms. Reed standing right there with them and with us. It may be done all the time, but
it may be something you're choosing not.
Is it? I've never heard of that before, but that's interesting.
So you don't want that. You want some combination. I don't know if we can do it without the combination.
We could.
I mean,
one of the things that we were talking about is potentially a closed circuit wireless microphone up at the bench and a set of headphones here that she can listen in on.
Put it all in writing. I
Okay.
would like to have had it before today. We've been moving around courtrooms. It may not be able to happen.
Okay.
All right. So the alternative is she can come to sidebar for any sidebar discussion and panel it, whatever. It's her absolute right. If she chooses not to do so, I'm going to need you to tell me that.
I'll put something in writing and perhaps I've got the plan in the back.
now he's gonna have to cite cases that like they do it.
Equipment that we need to make sure has priority. It's in the courthouse, so I'm not very hopeful that we can accomplish this in the next few days.
Okay, well, thank you for entertaining.
All right.
Wow.
One thing, when we
Jesus,
get the
dude.
juror questionnaires, the supplemental juror questionnaires that we talked about, and I need you both know what our decision is here, other than the 10-2 versus automatic. Let's go with 10-2. And I can either do that at sidebar or in the form. What I'd like you to consider, and lawyers have done this in other cases that I've had, is if there are answers that are clearly what you believe would both sides agree jurors excused for cause. In an effort to be able to go through this vast amount of jurors that the jury commissioner's office was kind enough to summons in for us, if things stand out to you, it would be ideal if you could agree that jurors number 8, 12, and 16, both sides agree should be excused for cause based on the supplemental questionnaires. It would be very helpful if we could do that, and maybe keep a running sheet that would be a joint proposal to excuse these jurors for cause. It may happen when you look through the questionnaires on folks that we sent home to have them come back the next day to just call 5 people. The court officers call them and tell them not to come in based on the questionnaire. So please think about that. It makes sense to me. It was very helpful when lawyers were able to get along well enough to do that in a case that we tried, that we had changed venues on because of the publicity also. All right, anything else?
No, thank you.
Your Honor, there was a motion for reconsideration that was filed with regard to the metadata underlined. I can.
You can make an objection. Go ahead.
I just wanted to make sure that the court saw that motion and that it was filed. I don't know if the court wants to hear a oral argument, I'm happy to do that, but we just wanted to make sure that that gets decided.
Okay. All right, there's still a few outstanding.
Thank you.
All right, anything else?
Not from this.
All right, we'll see you on Tuesday.
Court, all right, please.
All right, that's it. Wow. All right, so another hearing a week from today. Jesus, man. Yeah, I mean, a little bit of justice prevailed today. A little bit of justice prevailed today. Because that motion was gross. That was the defining motion filed by Hank Brennan that talks about that expresses his weaselness, his fucking sliminess. And even Bev wasn't having it. Even Bev was like, dude, like, come on. The fuck are you doing? You expect me to fucking allow you to look at conversations between her and her attorney? You expect me to give you that? That's crazy. No fucking way. Well, no, I'm not giving her too much credit. I'm not giving her too much credit. I'm saying that was a good move on her part. It simply was. Doesn't mean that she's, all of a sudden gonna start calling things fairly. I don't know about that. The impression I'm getting, though, she likes Alessi, she likes David Yannetti, hates Jackson, hates Karen. I mean, if what you guys are saying, because a lot of you guys are saying, yeah, man, that shit's done all the time. Headphones so she could listen in on sidebar. What's the problem? Like, everyone does it, right? But yeah, as somebody pointed out in chat, Bev hates tech. She hates anything techie at all. And B, why push back? It's like she was just pushing back on it because it seemed like some sort of special accommodation requested by Jackson and his entitlement on behalf of his client, who is just so entitled. That's how it came off to Bev. I'll take it into consideration, Mr. Jackson. I mean, like, so the fact that she hates text, she doesn't realize that it's done all the time. So she automatically is just going to push back on Alan Jackson on something like that. That's just what he's going to do. Let's drop in on Mike and Tom.
I know.
Yeah.
I know. And she's gonna rule on the buffer zone.
Make sure to give Mikey and Tom a like.
Third-party culprit tonight, I believe.
I am so pissed about that, Mike. That is such not right lies. Nothing but lies. The buffers, the stuff they sent in.
Oh, yeah, I know.
Those accusations about all the people at the Karen Reed stuff? No way, no how, never happened, Mike. Nope.
I know.
Nope.
I believe you.
Nope.
I was just telling Kelly that they should have had, if you don't want us to use the bathroom, just put a bathroom sign up. You know what I mean? Just don't even.
Where's Tom going?
Only kind of thing,
Is he not going to get?
Mike, we instructed everybody to go to the registry of deeds.
All right.
and to stay on the jury. Let's see.
What?
Let me find this question. There was some stuff about law enforcement. I'm finding.
Bro, shut up, bro. Hold on.
Oh, here we go. Yeah.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Mike B for the 413. Despite what we believe about Bev and her brother's past clients, Chris Albert, did Hank really think a defense attorney turned judge would grant that? That is career saving decision for her. Yeah, agreed. No microdots. Let's hear what this idiot's saying.
Right, because trust me, there is no way that this defense team thinks that there is any chance that 12 jurors are going to vote to acquit. There's no way, barring some new dramatic evidence that comes out. The prosecution is going to be light years.
No way he says that that you'll get 12 people to acquit Karen Reed. Of course they will.
If Adam Lally was prosecuting this case again, it would be light years better than the last case because they have time. They've had a year to build on what they have. They have the evidence in their favor. He would have had the time to learn from his mistakes. So even if Adam Lally was prosecuting this case, it would be seriously way better than the prosecution last time. But now we have a much more experienced, seasoned attorney.
Yeah, defense attorney.
It's into this. Someone who clearly is determined to win. And that's
right. Exactly. You just said it. Determined to win. Not determined to get justice for John O'Keefe. Determined to win. That's all he cares about. Otherwise, he would simply be focused on the evidence that he's so confident would convict Karen Reed. He would not be trying to cheat her out of a defense at every given turn.
Acquittal. There's no way you're going to get 12 jurors to ignore that fundamental evidence. So what the defense wants is to get one or two jurors to stand their ground. People that
exactly. You don't have to get 12 jurors to acquit. This is how much this fucking published author knows about the law. Like you don't have to get 12 jurors to fucking acquit, bro. Like you need to get 12 jurors to fucking convict. If they can't acquit, if they can't unanimously acquit, that's it. It's a not guilty verdict.
That's possible, right? So the defense wants that person to not feel guilty for having those feelings and those beliefs. And they want to fortify them to stand up and hold on. That's what the defense wants. And of course, even more scurrilous, the defense also wants that those people, listen, you run a PR campaign if you're a defense team for one reason, and that's to pollute the jury pool. That's it, to contaminate the jury pool. And it's been effective. It's worked. It worked last time. So,
but
that's been their goal all along. So they want those.
See, it doesn't count as a PR campaign when people with platforms are voluntarily promoting her innocence. My support comes from you guys. That's it. I get nothing from Karen Reed or her defense or Turtle Boy. I get nothing. My support comes solely from you guys. 100% comes from you guys. So I don't know what the fuck he's talking about. There is no PR campaign. The PR campaign, if there's a PR campaign, it is a self-employed, self-running machine that just simply believes that Karen Reed is innocent and the world should know about it. That is 100% my motives. Karen Reed is innocent and she should not be on trial. And I'm simply using my platform to promote that fact. Right. It's called pissed off citizens. As an American and as a patriot and as somebody who believes in our justice system and what our forefathers had in mind when they designed our justice system, this angers me. This shouldn't be happening to anyone. Yeah, this shouldn't be happening to anyone.
For the one that's holding out, that's a hard spot to be in. But it didn't seem to bother the other jurors who flocked to Turtle Boy right after the trial. And we're talking about 3 of them, I guess, possibly 4. Now I'm including the alternate juror and the dismissed juror. And they all go running to Turtle Boy, which is very suspicious. Look, even if you're an honest, diligent juror that believed during the last trial that there was reasonable doubt, or believed that at the very least the state, reasonable doubt, the state didn't prove its case. The idea of going to him is stunning to me.
Jesus, dude, you are fucking retarded. Jeannie Lynn, thank you so much. Thanks for bringing this to us in a humorous way. We need that. Yeah, man. Thank you for watching. I mean, here's the thing, dude. It's like, yeah, this whole talk of a PR campaign is just fucking stupid and ridiculous. I have never gotten 1 red cent from Karen Reed or anyone in her camp. Not 1. And I'm saying this only to reiterate my point. I'm not complaining in any way, shape, or form. But I have spent money. What I do is I take the money that you guys support me with, and I travel to Boston to support you guys and to support Karen in person. And if Turtle Boy or Karen even invites me to a dinner, it's simply to show gratitude for me using my platform and using my funds to give back. That's it. That's not running a PR campaign. That's just being like, yo, I acknowledge what you're doing and I appreciate it. Cool. And I get to break bread with them and say that I appreciate them. Like, that's it. That's not in any way, shape, or form trying to control some sort of narrative. That's me just having my own mind, my own opinions, expressing them, and people being grateful for it. And then me showing gratitude in return. That's it. It's a very positive exchange. Thank you, Jody 617. 1,000 red cents. Thank you. Yeah, Microdots knows that shit. Yeah, like I don't even know. I don't, like, if you guys knew the lifestyle I led, like I don't need things. I don't need things. I'm not one of those people. So it just seems like the thing to do is to book a flight when I can to Boston and a hotel room and support Karen in person, support the supporters in person. It seems like, okay, well, what the fuck else am I going to do? buy something that I can't even think of that I want. I don't even look at stuff and go, oh my God. I haven't done that in years, where I look at stuff and go, I gotta have that. Like, yeah. So, I mean, dude, I'm simple because I'm just fucking lazy, dude. It's a lot. You know why? You know why I really stopped like a desire for things? It's because I was so fucking poor most of my young adult life that I had to move so much. So I was like, I don't fucking need furniture. Like, that's crazy. Like, I don't want to move shit. So the less shit I have, the less shit I'm going to have to move. This is the most stability that I've ever had in my entire adult life right now. And so it's gotten to a point where I have surpassed the age where I feel like it's somehow logical to get married. The idea of getting married at my age now, like, I've totally circumvented that shit. I circumvented that shit. If you're my age and managed to not get married all of this time and you get to be my age, you're like, dude, that would be the stupidest fucking thing that I could ever do. I'm going to tell you right now. Like, let me fucking tell you that marrying somebody, dude, I'm going to give you guys the most honest reason why I am never going to get married. Okay? The most honest reason. I'm way too busy doing whatever the fuck I want when I want to. Having to like incorporate another person into everyday decisions, like what I'm going to eat, what I'm going to watch on TV, what movie am I going to watch, where I'm going to go that day, when I'm going to travel. Fuck that. Fuck that. Dude, every guy I know that's married at my age is fucking miserable. I don't give a fuck what they say. They could smile all day and be like, oh, no, I'm so happy. No, you're not. No, you're not. No, you're not. You're not nearly as happy as I am. I'll tell you that right now. You are not even close to as happy as I am. I'll tell you that right fucking now. So, yes, I am. I'm to the point where I find like material things to be just very arbitrary, and sharing everyday fucking decisions with someone else is fucking even more. It's absurd. The notion of incorporating someone else into my everyday decision making is fucking absurd to me. Now, I'm not trashing anyways. Once in a while, there's that exception to the rule where you got a married couple who is totally their best friends. They can't imagine themselves. I do think true love is a real thing. Don't get me wrong. The fact is, though, is 50% of marriages fucking end in divorce, dude. There's a reason for that, because it's a very rare thing to have that connection where you actually do find your soulmate, right? And you are actually happy for the rest of your life. Couldn't be happier. But that's more rare than it is common. So, yeah. Dude, the idea of a woman coming into my life and being like, I can't sleep with the dog on the bed. Let me see if I can get some blankets and shit to throw on the floor for you then, because I mean, I'll try to make the floor as comfortable for you as I can, honey. That's why I'm not married. That's exactly why I'm not married. There's just no way. So I'm gonna, Nan, I see you in the chat. I'm gonna get with you about a time for tonight. I think I already have one in mind pretty much, but But yeah, and then we'll go over this stuff again tonight because I want we all love Nan's insights, and I definitely want to get her up here and let you guys ask her questions and whatnot in regards to what we're looking forward to in the trial and what happened today and all that good stuff. But yeah, I think this is a good place to wrap this up, man. So thank you guys so much. I hope that if you're new subscribers that you're enjoying the channel and continue to do so. And thank you for subscribing, and make sure to hit the like for me on your way out if you can. I would really appreciate it. Scott Messerschmidt, all the mods, thank you guys so much for everything. You guys are amazing. And thank you guys for all the support. You guys are absolutely fantastic. I can never express how grateful I am to you guys for this. But I love you guys very much. And I will see you guys later tonight. And don't forget that Friday, 6 p.m. I haven't set it up yet, like on YouTube, but it's a set time. It will be happening. I'm going to have Justice Serve TV, Michael and Linda on. I'm really looking forward to that. I think they're great. Oh, wait a second. Something just came in. I just got something here. Hold on. I was just about to wrap this up, but I might be going over something, or I'll wait till tonight to go over it. Oh, and I can't even open it. So, yep, I need to subscribe to it. Oh, well. All right, guys. That's it for me. I love you guys very much. We will do this again very soon, my friends.